Hello, everybody. How you doing? Okay. As Jerry Buting would say, red letter day, right? Red letter day. So, obviously, some of you, or most of you, have now found out that the Court of Appeals has decided to remand this issue back to the Circuit Court for potential fact-finding. Of course, we have the same obstacle of Judge Suck. Judge Suck, right? Anyway, but, you know, hey, look, maybe she's going to be like this time. Maybe she's going to be sitting there going, okay, look, I just flat out denied that 1,000-page thing. Then something got remanded back, and I just kind of blew that off. Maybe she's going to be thinking this time, like if I don't actually give it like honest consideration this time, I might get myself into some hot water. Maybe she'll reason that way. Who knows? We'll see, obviously. But no matter what happens, this is good. No matter what it's kind of good no matter what Judge Suck does. But preferably it would be good if she held an evidentiary hearing finally. But who knows? Because even if she denies it again and does all that stuff, it goes right onto the appellate record, and we're right back in the appeals court, except now we have one more added piece that gives it that much more punch. So no matter what, this is all good stuff. So I thought first maybe we might just go ahead and get Stacy's take on it first, and then we'll come back and we'll start going through the documents and stuff with Travis here. So
the day always comes if you're innocent.
Get on the train before it leaves the station. Wisconsin versus Avery, a complete fabrication. Get on the train before it leaves town. The truth train is coming, gonna run them down, run them down. And we all know Stephen and Brendan were blamed, but it does not take a brain surgeon to see that they were framed. And yes, we know what this was about. The civil suit, the settlement, they did not want to pay out. And you may hear this song, or maybe you don't get it. I suggest you look up TikTok, Manitowoc on Reddit. There you will find trial transcripts, evidence files, and reports, and you will start to fathom the corruption within the court. And as you shake your head, because everything is demented, you will find yourself in company of 3 unbanked judges that dissented. But don't you worry, you're not going insane. You just happen to sit down on Zellner's true train. Get on the train before it leaves the station. Final destination, inevitable exoneration. Get on the train before it leaves town. The truth train is coming, gonna run them down, run them down. Get on the train.
All right. There we go. Get on the train. Get on the train. So, get my camera. There we go. Hello, here I am. So, yeah. So, big day, obviously. Now, I will remind some of you who may be coming in off of MAM2, didn't really follow for the first 3 years, like me and the Ali Appersons and the various other peoples of the world here who we've been in this for 3 years. Keep in mind, something has been remanded back to the circuit court before. So, this is good. It is absolutely good. But I want to help people keep their expectations in perspective, or at least to know what the possibilities are, so that as this progresses, you kind of know what to expect to a certain extent. Anyway, when it gets to the law, sometimes it's Quicksilver and it just does strange things, But anyway, but no, but seriously, it is good. Everybody's happy about this, and that's good, and it is something to be happy about, because for me, this is now the second time. This is now the second time that something's being remanded back by the appeals court. The appeals court is finding, or they're feeling it necessary to send these things back when they're coming up, when Zellner's showing them, like the CD was the first thing. The CD, which had all the Detective Veely's, findings and everything on it, or whatever, that was held in Tom Fassbender's personal custody for 12 years, right? When that materialized, Zellner brought that to the Court of Appeals or whatever, said, look, this was, this is a Brady violation, right? And she was arguing that got sent back to the district court, the circuit court. And we know what Judge Angela Sook did. Judge Sook did what she does best. She sucks. So she basically, just without even much consideration, really. I think she even said in her decision, she was like, she kind of admonished the state for even filing a brief because she didn't ask for one. I think I remember something like that in her decision over the CD.
That's correct. That's right.
Right. So, it was wild. So, who knows what we can expect from Judge Sook. It ought to be interesting. But no matter what she does, all this information is going to become part of the record. It's going to just join that mountain that's on appeal already. This is just going to be added to that mountain. So, and we know the recent Supreme Court decision, folks, that has really, really changed the face of the way that Wisconsin is going to interpret Brady. Okay, that's going to be huge, because when this thing does go back to the Court of Appeals, right? If it goes back, unless Judge Angela Sukowicz suddenly gets an honest streak in her, runs an evidentiary hearing, and Stephen gets a new trial. But anyway, if or when it does go back to the Court of Appeals, then that Brady development with the Supreme Court is going to help Zellner with her Brady claims that are in the appeal. So it's going to give those claims more teeth moving forward. So I think Zellner's starting to look pretty good now. Some of the recent developments are starting to, I think, break Stephen's way or Zellner's way, or our way, however you want to look at it. And so I think it's really, really good.
I think she's always looked good.
Yeah, well, that's true, but we're going to talk about that. Somebody said that they thought the COA sounded pissed. I agree, and we will get to explaining what we think about what the Court of Appeals said here in a second when we start running the document. Jamie says, hello, Travis.
Hey, Jamie, how are you? I can't see the chat because I've got the responsibility of running the document tonight. Maybe later I can switch over, but Eric Jose is going to be monitoring the chat, trying to get all your questions. When we do get to the document, I'll be running that. And so that's why I'm not saying hello to everybody, but hello, everybody.
Oh, dang it. Hold on.
I can't see you. What'd you drop?
What's that now?
What'd you drop?
Oh, it was the speaker. It fell off the desk. And okay, so when he should have just burned it if he never wanted it to be discovered. Talking about the CD. Well, I'm glad they didn't do that, because that's a big part of Avery's case now. Let's see here. Now are they recognizing they broke the law and are suggesting that the CC determine that? Well, no, what they're doing is sending this issue back to the circuit court because they want to have more fact finding on it. Is Judge Suck going to give them that fact finding, or is it going to come right back and they're going to have to decide whether or not Judge Suck is giving these issues a fair, if she's weighing them honestly, you know, and I think that's what it's going to come down to. I really don't think she is. I mean, when I read her decisions, it seems pretty obvious to me that she is skimming, you know, and kind of really doesn't understand most of what's there. At least it appears that way, you know, from the way she writes. So it's only her own fault that it appears that way. Mr. Capaldi. Hello, Mr. Capaldi. We got something special for Mr. Capaldi today. Let's show everybody before we get into it, before we get into the what's going on here. Let's have a little fun with Mr. Capaldi. From the Wrecking Crew to Mr. Capaldi.
Hello, Sir Paul / Donnie. How you doing?
There he is. Hey, how's it going? What's up, Paul? We're glad you could be with us, sir. I love it. I love it. All right. So
Look, your volume really dropped out for me. I don't know if that happened to anybody else.
Uh-oh. Hello, hello? Is it better, worse? Can you hear me? No? Let's see here.
Say something, dude.
Mom says she can hear just fine.
Okay.
All good. Everybody out there says they can hear. It might be your headphones, buddy. Yeah, everybody's saying the sound is good. Yeah. So, yeah, you can hear me there, right? So it must be your headphones.
Yeah, perfect. You have an echo?
I heard an echo, yeah. That's how I knew it was coming out of your speakers. Okay, thanks, guys. Thanks. I think Travis is having a technical issue with his headphones there, which means I also should put mine on. Hey, Julie Johnson, I need you to check your email when you get a chance.
I don't know. My headphones are fried, but obviously we can't do it with an echo.
Does anybody hear an echo? How's it going, Falcon? Okay, so nobody's hearing any echo. So, all right, let's proceed.
Okay. All right. Where are we at? What do you want to do?
So, well, let's see here. Sounds like you're havering. Sounds like I'm havering. Yeah. Well, you know. All right.
Havering or wavering?
Just had to see Paul's response real quick. All right. So, folks, we're going to go ahead and I'm going to let Travis put the document up here, and we'll start going through the Court of Appeals order, I guess you would call it.
That's exactly what it is an order. Is that up? Everybody can see it. Everybody can hear. We're all good?
Yep.
Okay. Let's just start going through this. And, you know, so if you have a question.
Before we get started, sorry. That's cool, Julie. Just when you get a chance. Sorry, I just hadn't got a response from you. I was worried, so I'm glad to see you're okay when you get a chance. Sorry. Go ahead, Trav.
I corresponded with Julie. I knew where she was. She was held up. I won't say where. I'll let her share.
Sure. Well,
okay. So, what do you want people to do if they have questions? Just go ahead and ask them in chat, and we'll.
I would say for everybody to try to save your questions for the end. If we're going through it and something just burning, and you got to ask it, go ahead and ask, and if we notice it, and we'll try and address it. But
I've
generally try to wait till the end if you can.
Yeah, I've already written down a couple. Daisy had one. What is conduct, quote, necessary proceedings, unquote. mean, and I'm going to get that one at the end, and got another one. But yeah, if you can wait until the end, and we'll spend as long as it takes to answer everybody's questions. Okay, so
So what we have here, folks, is the order from the Court of Appeals. The judges there, and we have, it's obviously from today, February 25th, 2019. It's showing that it's going to Angela Sukowicz. That's the judge there at the circuit court. Let's go down. Obviously showing Steve Richards. That's the co-counsel with Zellner. These two are from the Attorney General's office. That's why they're highlighted.
Yeah, they're the attorneys of record on the appeal. And so Williams and Fallon are attorneys of record in the circuit court. So when it's been remanded back, and so who will be handling the matter in the circuit court will be Mark Williams and Fallon, at least. No, Fallon.
Gone in Williams.
Right. That's who's listed down there.
I just have one question.
Sure.
Is Mark Williams taking Ken Kratz's place in Alibi? I'm just kidding. Anyways, never mind.
That's too funny. Okay, so all right, so I've highlighted who signed the motion. It's just one judge.
Right. It was a clerk. I thought it was a clerk.
No, see it right here in purple before.
Okay.
So they dictated the order, and you're right. It's signed, clerk of the Court of Appeals, but that's below the line, meaning they filed it on behalf of the court before. A clerk can only issue very limited orders on scheduling and whatnot. So, but what's significant about this is they're only mentioning one judge. It could have and Riley is the motion judge. But if it was getting complex or cumbersome or didn't want to decide it alone, he could have brought in the full panel. Then remember who else is on this panel. Neubauer, who's running for Supreme Court judge, and then the gentleman who's also running for Supreme Court.
Right.
It appears that it was just Riley who decided it rather than the whole panel. But talking to Tracy earlier on this today, and just not sure about that. But so it may have been just Judge Riley. And, there may or may not be any significance with the upcoming election why it was just Judge Riley and not the others. But, it's just all speculation. So Judge Riley starts off, apparently just Judge Riley, the presiding judge, by restating what's before the court. And Avery, by counsel, appeals from the circuit court's denial of his 97406 post-conviction motions. That's what's on appeal. That's what the brief that was due on the 21st was going to address. However, as we know, in the interim, this motion came up. He moves the court to stay the appeal and remand to the circuit court may raise new claims based on the recent discovery of a previously undisclosed police report dated September 20th, 2011.
Right.
According to Avery's counsel, law enforcement transferred multiple suspected human bones from the Manitowoc County gravel pit to Whiting Funeral Home for return to Teresa Halbach's
family.
So a couple of things here. They restate what it is that Zellner is asking the court to do.
Right.
He's moving this court to stay the appeal and remand. Because judges frequently do this, because when you grant or deny at the end of the document, this sets out, what it is they're granting or denying. So, and then, they're pointing this out, that the main thing, they return bones to the Halbach family. Okay, so now we're on page 2.
Right. Avery alleges that the state violated its statutory duty to preserve evidence. Wisconsin Statute 968.205. That's the one written by Gahn, everybody. And I just can't tell you how much I love it that it's coming back to bite them in the ass. Let's see. The state's actions violated Avery's constitutional due process rights. See Youngblood versus Arizona. So, right. Avery, go ahead.
So what's important here is the judge isn't commenting on the viability of these claims. He's restating what the basis of the motion is. Okay, so repeats it, claiming 2 violations. And we've been through all of this together on videos and whatnot. And Tracy's done videos on it, commented on our Facebook page. But, we've been following this along from the inception. And, these have been the 2 things that jumped right out. As a matter of fact, in your video on December 18th, the Wrecking Crew researched this statute, had it all ready for us to go to talk about on September 18th, back when, we discovered
December 18th, right?
December 18th of 2018 that the bones had apparently been returned. Right. So this motion, is and this order is with the significance of the giving away of those bones.
Right. Now here's the good bits. Sorry, anything else?
No, then we're into the next thing. Now, he repeats.
The state has filed an objection to Avery's remand motion on the ground that it constitutes a new and separate action, even though it's the same thing. 97406, even though it's the same thing. Anyway, okay. But moving beyond that, which is unrelated to the orders Avery presently appeals. It is unnecessary to the resolution of his pending appeal and would result in unnecessary delay in litigation. The state's objection points to this is, in effect, Avery's 3rd remand request. The state's objection does not address the merits of Avery's claim to statutory and constitutional violations, and it has not responded to Avery's supplemental filings alleging that the possible destruction of the evidentiary items, which it appears the parties previously agreed to preserve. So that's just to let you guys know, when the orange got put in here, that was kind of like us envisioning that's the Court of Appeals kind of bitch slapping the state of Wisconsin.
You said it, not me. You said it. It is a bitch slap, but you said it.
Hey, look, that's a pretty common term. I don't know. Anyway.
Well, you sasaid it, but yeah.
I said it. But anyways, that's what this orange is. This is pointing out where the appeals judges are pointing out, the very obvious. Why didn't the state argue the merits of this? Right there, so that's interesting that they're pointing that out. The state suggests that the appeal is languishing. And as Travis has said many times, appeals don't languish, people do. So, and that if Avery wishes to pursue new claims outside the scope of Wisconsin Statute 97406, wait, this is a 97406. It's weird sometimes how the state just doesn't make sense. Anyway, post-conviction order is presently on appeal. He could dismiss the pending appeal or wait until its conclusion until its conclusion to file new claims. As to the former, Avery understandably disagrees, aware that dismissing his appeal would preclude review of the underlying orders entered to date. So it's in orange again, folks, because that's the Court of Appeals going, what the flip is the state smoking, expecting somebody to completely dismiss their appeal? I mean, that's the way that comes off to me anyway.
No, that's a correct interpretation. Avery understandably disagrees.
Yeah.
They're basically sending a message to the state. You need to come up with a different argument.
Yeah. Right. All right. So, having considered the parties' submissions, we determined the best course of action to grant Avery's motion to stay and appeal and to remand under Wisconsin Statute 808.075 for action upon specific issues. As the state's response acknowledges, the decision to remand is left to this court's discretion. I like that. I like that. The way they put that in there. I think that should be a little orange right there on the end of that too. Anyway, though we are not required to remand, we determined that this procedure strikes an appropriate balance given the specific circumstances of this case. Due to this case's extensive history.
Wait there. So appropriate balance. So there, this is silently referring back to why the judge didn't grant the motion to do testing. Is that indirectly he's saying there wasn't an appropriate balance for the rapid DNA testing.
Right.
And that specific circumstances of this case, they're limiting, because this order is going to go worldwide. I mean, there's just no question. Mm-hmm. It's just the way this case is looked at. It was written, especially everybody in the state bar of Wisconsin is going to be aware of this order. And so they're telegraphing, look, this case has specific circumstances. This isn't going to happen in every type of case, but given the specific circumstances. But I wanted to point that out. Those two terms have some significance.
Right. So due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh. Well, you mean because the state will start playing games and muddy the water? Uh-oh. We do have another bitch slap here, pimp slap. Rather than positioning the claims to be procedurally barred in future proceeding, which is what we were getting at. That's why the state wanted the Court of Appeals to just deny this or whatever, and so that they didn't have to argue the merits, because they were hoping that by the times, later on down the road after Stephen's appeal ran its course or whatever, that if he tried to bring this then, that he might get procedurally barred from bringing it, because they would ask why he didn't bring it now when he found out about it. Well, he did do that now. So
precisely. And
that's what people need to understand, is that he did do that now. And that is precisely why people think Zellner is wasting time. No, Zellner is making sure she doesn't get Stephen's chances at freedom taken away. That's part of it. You guys, there's so much to understand that's going on here. So I really got a little depressed when I saw so many people thinking that Zellner was wasting time, that they were believing that tripe coming out of Wisconsin about a month ago or whatever, when they were trying to suggest that Zellner was gumming up the works here. It's not Zellner gumming up the works, folks. It's the state. They're not turning things over. They're holding things back. They're holding CDs in Tom Fassbender's personal custody for 12 years. That's the state. The state is doing those things. And the state yet has the gall to try to say that Zellner's the one doing it. And that is just off the flipping charts. Anyways, so
tell me how you really feel.
Yeah.
I made a note that about fair weather friends. I'm really starting to question Zellner. Heard those kind of comments from numerous outlets. It's frustrating. She keeps asking for these delays, and you and I, along with others, Tracy and many others, but it was like pushing a boulder uphill to have it roll right back down to explain, look, there's this thing called the procedural bar. Right. There's waiver there, and even if she loses, she wins. Right. And she's preserved the DNA testing with that first motion. Frankly, if she gets an evidentiary hearing on this, we'll talk about this later, I think she can re-hook back in rapid DNA testing, but we'll just have to see what the judge does with that. But no, and here's the court pointing out, rather than positioning the claims to be procedurally barred in future proceedings, they want this stuff to be litigated while it's relatively fresh.
Right.
That judge is saying, I'm not concerned about this appeal languishing.
Yeah.
Let's get it done, while we can and it's the next sentence. And we've said this over and over and over again. You have to bring everything together in one brief or it's barred. And so why does she keep delaying right before the deadline of her brief? Well, she has to make sure that every possible issue that she can discuss has been discussed or it's barred.
Right.
And so, now, I'm sure everybody is going to be back on the, genius bandwagon. I was never off the bandwagon. She's a brilliant post-conviction attorney. She always has been. And she remains to be a brilliant post-conviction attorney on this case. And what ends up happening, who knows? But, it just goes to show, her brilliance and her tenacity are unwavering. And she's not doing this stuff for entertainment value. And I understand that that's frustrating. Then the other component is people went through that have been following the case, for a long time. They went through that emotional roller coaster with Brendan, and that takes a lot out of you. And I understand it gets frustrating on this side, that it's, oh boy, we're back to this roller coaster again. And it's not a fun ride sometimes.
Oh,
but anyway, so we left off.
I learned that after following Brendan. Anyway,
yeah,
that one was a real, nut check on that one. Anyway,
no, it was. I mean,
that was horrible. Yeah, it was such a letdown to see what happened there. It was just like, wow. I always heard that winning previously was supposed to work in your favor. Apparently not. Not when you're a Dassey or an Avery, I guess. But anyway.
Right. So we're at for these reasons.
Yeah, for these reasons, we desire a ruling on the merits so that all the claims to date can be considered in a single appeal. There appears to be some potential overlap between the old and new issues. Therefore, it is ordered that this appeal is remanded forthwith to the circuit court to permit Stephen A. Avery to pursue a supplemental post-conviction motion raising claims for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood versus Arizona.
So those are the exact two issues that she set forth in her motion. The court could have said, we don't think 968.205 is suitable at this point, and so just Youngblood v. Arizona or vice versa. But she framed the issues that it was under both the preservation statute and due process.
Right.
And so this next line is for Julie Pompom and her website with
Earned Abs.
Yeah. And now she'll be able to put in there, if she hasn't already, that it's been ordered granted. And then
someone's asking if she can ask for an extension on that. That's a no, right?
Sure she can, but she's got to go to
she has to ask Judge Angela for it.
Yeah, that ain't gonna happen.
Yeah, so, don't ask Judge Suck. Forget that.
So that's but she's not gonna need she's not going to need much time on that. She just needs to relabel what she's submitted already. And, knowing her, she probably already has it ready to go, quite frankly.
Right.
So will she, the other question always comes up. So even if the deadline's March 11th, can she file it early? Yeah, she can. Will she? Probably not. Why?
Mhm.
Because if who knows who's going to be calling and leaving a voicemail on her
Right.
phone next week?
Right. Exactly. Can't miss any of those Mark Williams calls. If another one comes in, you want to add it in. So,
Yeah. So Julie will switch her
a
thing.
fourth pimp slap.
What?
I said a fourth pimp slap.
Yeah. Okay. So
It is further ordered that the circuit court shall conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and shall enter an order containing its findings and conclusions.
Okay, so hang on.
Yeah.
So we're gonna take a brief pause, and we're gonna go over here. You still have that on screen?
I see it.
Okay. So what this is, a lot of you are familiar with this and know how to access the Wisconsin court system for filings and whatnot.
Mhm.
This is the appeal. This is all of these receipts right here are people buying copies of previous orders, and then had a lot of people. Someone came in there and bought a copy of the order, but that's what these invoices are for. So here's when her brief is due, 40 days after the return of the record. They have 5/14/2019. That looks to be just as a placeholder status. When her brief is due is on a hold status. The record, they've just put 5/14 to follow up on it, due 20 days after the entry of the court. We'll get to that later. But so here's the order from today. It shows, when the motions were filed, when the decision date. So that's for the motion we're talking about today. So we're going to go back down to the CD disc and look at this language. So May of 2018, she filed a motion to supplement the record about the computer CD disc, and they put further order that the court shall conduct any necessary proceedings and enter an order containing its findings and conclusions. And then they gave 60 days to Judge Angie, and they also gave Zellner 30 days to file her motion. So we're going to go back to. So here they've given her 14 days, and they have that same language. Shall conduct any proceedings necessary to address the claims raised supplemental post-conviction motion. The last go around, Judge Angie Flower-Suck mentioned in a motion to remove her as judge, to substitute the judge, said, contrary to what Zellner states, this court has not been ordered to conduct an evidentiary hearing. So we know Judge Angie doesn't take this language right here to necessarily mean that she has to conduct an evidentiary hearing.
Right.
However, the circumstances of this motion and the language that's laid out in this order, the language about that none of the information find that they didn't go through what the facts were. They didn't. They chose just to argue procedure.
Right.
The state's objection does not address the merits. It has not responded to Avery's supplemental filings. Apologize.
Yeah. Don't
I don't
you
have
hate
any
that?
way. I have
And,
no
then
way.
and now they just roll in, right?
I have no way to shut that off.
I hate it when that happens.
It's the CIA. The state's objection does not address the merits, not responded to Avery's supplemental filings alleging the possible destruction of evidentiary items. This is the court telling the circuit court they want answers to those questions. The only way for that to happen is typically an evidentiary hearing. Now, she could ask for briefs with affidavits attached, but that's really not the way things are conducted. But so shall conduct any proceedings necessary to address the claims raised, supplemental post-conviction motion.
Right.
According that to her, that doesn't mean she has to conduct an evidentiary hearing.
Exactly.
So we're going to have to wait.
Judge Angie, that means do nothing. Right.
Well, it can be, but there's a lot of stuff up above that's sending a message.
Yeah, I know. Right.
Whether that makes a difference or not.
We'll see how Judge Angie interprets it this time. We'll see.
And then the rest is similar to the other stuff. Or a transcript, and this was the same in the other order I just showed you all, that a transcript means that there's an evidentiary hearing. That's the only way that there's a transcript. If a party intends, so it kind of presumes there's going to be a evidentiary hearing, but that wasn't the way it happened last time.
Okay, hey, is there a word limit for KZ's next filing? Somebody's asking over and over.
A word limit on her.
Is there a word limit on her what she has to file with the circuit court?
No.
No? Okay. So no word limit. And Julie said it was asking about it, since it says that they have to hold proceedings, is that the same as ordering them to hold a hearing? So what we were just saying, Julie, is you would think so, but we know from the wording of the last time, the same wording was used last time, and we know what Judge Suk did then. So we're looking at it going, okay, they used the same wording here, and we know that Judge Suk interpreted it a certain way last time. So there's a fair chance she could interpret it the same way this time. The point is, no matter what Judge Suk does, it's all going to go back to the appeals court. Well, unless Judge Suk deals with it honestly, in which case it could trigger a new trial for Avery. But in
the state, you're right. Either way, it's going back to the Court of Appeals because the state's going to appeal her.
Right. It would appeal Judge Suk. Right. Okay, gotcha.
Right. But we've got to have. There may be some pretty nefarious stuff that they don't even want to mess with an appeal. But barring that, if it's going to get whoever ends up losing on that side of it's going to appeal it back up. But if the court if they found a Youngblood violation, if the circuit court, we'll just take the personalities out of it. Let's just assume maybe it's a different judge, but because you just don't know, she could get appointed to the Court of Appeals after the election. Who knows? So let's just call it the circuit court. But if the circuit court rules there's a Youngblood violation, that's an automatic new trial. You're correct. And then you have to wait and see if the state's going to appeal that up to the Court of Appeals, and then the Court of Appeals will have to deal with it. And then if either side's unhappy with that decision, then you file a petition for review with the Wisconsin, guess who?
Supreme Court.
Supreme Court. So what happens on April 2nd?
That's the isn't that the date to register?
No, that's the date of the election.
That is the date of the election. Okay.
For Supreme Court. That's why that's a big, big day if you know anybody that lives in Wisconsin. But
right.
Here's the language right there. Further order, the circuit court shall conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the motion is filed. That time limit is not in this particular one. And so it doesn't have that constraint, but it does have this language, shall conduct any necessary proceedings and enter an order.
Right.
And she felt, the last one didn't require an evidentiary hearing with that language, and shall conduct any proceedings necessary to address claims raised in the supplemental motion.
Right.
So we'll just have to wait and see what the judge does with it.
Vanessa Overton, no, Judge Suck cannot be replaced at this point in time. There will possibly be a point in time where that might be able to happen, but not yet. Eric Jose, did you read the decision to say that they also opened up to KZ and even almost demanded that she file any and all new topics stating that any and all items should be consolidated? So that's, I don't know that they were really saying that to KZ today. That's just kind of what it's supposed to be. You're supposed to bring all these things together. The state's arguments in this are like bizarre. They go against judicial, budgeting or judicial, being judicially fiscal,
Judicial economy.
Right. So what the state's arguing in this is going against all of that. And what the appeals court's saying is we think we'd like to go ahead and have everything gathered together here and all done in one go in a timely fashion rather than stretching this out over time and allowing, potential issues to arise. I would say shenanigans, but I'll say issues to be nice.
Right up here. No, I don't read it that way at all. We determined that this procedure strikes an appropriate balance given the specific circumstances of this case. Due to this case's extensive history, there's a benefit to having existing claims developed or litigated while they are relatively fresh. She's always under a duty to bring everything at the same time.
That's like the way it's supposed to be.
But you can't control what people hide from you and what you end up discovering in the interim. And that's why they have this rule, 808.0755, to remand for specific issues, because unfortunately people hide stuff, or people, it can happen even when they're not hiding things. New cases come out, other things happen. But no, I don't read it that way at all, that, this is the last extension we're going to give you, or this is the last remand. I think it's just the opposite.
Well,
if there's another situation where there's an appropriate balance under the given circumstances of this case, and there's a benefit to having everything heard at one time, they'll remand it as many times as it takes.
Right. So yeah, I'm not, and I'm not saying that. I was just talking about wording. Obviously, the courts and the judges worded things a little more politically or correct, or a little more PC. I guess what, and then me, because generally courts won't use words like shenanigans when referring to the state. So anyways. like I would.
So they use stuff like Avery understandably disagreed, aware that dismissing this appeal will preclude review
I'm surprised it doesn't say
entered to date.
And I'm surprised it doesn't say in regards to the state's disingenuosity.
Yeah. Specious argument.
Right.
But you know, the rest.
So we'll read that. So it is further ordered. Go back up. It is further ordered that the party intends to order transcript and post. Okay, so you were already talking about the transcripting stuff. Let's go down. Clerk shall retransmit the record within 20 days of Judge Sook's order. So within 20 days of Judge Sook making her decision about this, the record has to get transmitted back to the Court of Appeals. It is further ordered that the appeal is stayed until the return of the record following remand. It is further ordered that the appellant shall file an appellant's opening brief presenting all grounds for relief within 40 days after the return of the record. Now that's referring to when or if it comes back to the Court of Appeals, Zellner will have 40 days from the day that the record arrives to file her brief in the appeal moving forward, which will now, if that happens, it would then have all of this bones issues added to the appeal, and that would all be moving forward.
Yes. Yep.
So that's basically what we got from the Court of Appeals today, folks. It's good news. It's a positive development for Avery, which is nice because he doesn't get a whole bunch of them. Can KZ include any violations she's alleging, or only the one from this filings in regards to the bones having been given back? So yes, this is going to be specific. The Court of Appeals is remanding it back, and they're pointing out that it is going to be a specific, targeted, look at the bones alone, the issues with whether or not they've been handed back, whether or not they were, all the issues surrounding them.
Tracy just sent me a Newsweek. Here's the way. Now, this is Newsweek, ladies and gentlemen. This is why you should be proud to be a subscriber of Eric Jose's channel. Newsweek headline: Making a Murderer, Stephen Avery won his appeal, could get a second trial. So you folks know that he didn't win his appeal. He won his motion to remand and stay, and then we're going to take the next step. So you folks will have to be out there letting people know that there's still a long road to hoe. And I'll say it again: if you know anybody in Wisconsin, or if you meet somebody in Wisconsin, please remind them that there's a big election on April 2nd and encourage them to vote, because it's historically a very low turnout election. It's just for Supreme Court. I don't even know if there's anything else on the ballot, and they're predicting less than a 20% turnout. And so every vote, as a consequence, is going to, be significantly more important. But ultimately, this thing's going to end up there, whether they decline to hear an appeal or whether they actually grant a petition, whether it's the states or the Stevens. So yeah, today is a great day, Eric Jose.
Yeah, I agree.
It's
red letter day.
All the naysayers and all of that. What's she doing? She doesn't know what she's doing. This is crazy. This is crazy. And taken what the state's attorneys put in their response as gospel. Oh, she's just a stupid idiot. She could just dismiss this. Well, you saw what an appellate court judge, how they dealt with that. So I doubt you'll be seeing these lame arguments again. That's for sure, from the state.
Right.
Specious arguments. And you'll you'll see I think you'll see the level of what did you call it? Disingenuosity.
Yeah, there you go.
Disingenuosity level's gonna ramp way down from those people.
Oh, Ali says, Newsweek, I swear, all they did was read Zellner say, "We won," and jump to the conclusions without reading what she had won. Yeah, well, hey, look, Newsweek isn't too quick in the uptake. Look, they were reporting about the bones a month after us, a month after the Wrecking Crew here on my channel. So Newsweek isn't. I mean, it's great that they get around to it eventually. So I don't want to be too derogatory, but they aren't the sharpest tool in the drawer. They're, So anyway, but hey, at least they're reporting on it.
Are they even a magazine anymore? Or are they just online now?
I'm actually not sure.
I don't even think they're a magazine anymore. Now I understand why.
So I am here. I did not understand that paper. Impressive word. Oh, Kim K says that disingenuosity is an impressive word.
One he just made up to substitute, which I like better than disingenuous, but disingenuosity,
Well, because disingenuous is like, that's referring to somebody being disingenuous. But when you're referring to the quality of being disingenuous, right?
you converted it to an adjective from a verb, which I'm very impressed. Very impressed.
Hey, dude, like I said, my dad would have been an English teacher if he hadn't been drafted to Vietnam. I would get like my head knocked if I walked through the house using improper grammar, improper sentence structure, that type of stuff. That's why when I see Tom Fassbender talking about the control question, it's just like freaking A-bombs are going off in my brain going, what the fuck is this idiot talking about?
Yeah. Well, so, I think we need a little sign made, Falcon's a brilliant graphic artist. Is he still on? What you need is a T-shirt, a sign, disingenuosity free zone. This is a disingenuosity free zone in here, man.
I like it. That's a good idea. Oh my gosh.
He designed a brilliant Wrecking Crew shirt a month or so ago. It was beautiful.
Can't wait to get the opportunity. Let's see here. Oh, Kim K can't wait to get an opportunity to use it. Basically, when the hell is the yin yang going to stop? Go on and on for a while, Caden. I mean, we were wondering the same thing with Brendan, and then it did. And then we were wishing for the yin yang again. Because even that would have been better than what happened. How do I know one corrupt judge from the next one on who to vote for? Well, familiarize with the issues, familiarize yourself with what those judges stand for, and try to pick the one that stands more with the stuff you believe in. If that's criminal justice reform, then try to figure out which one of the judges is more prone to actually create meaningful criminal justice reform. If you're more worried about some other kind of issue, research the judges and find out what they stand for, and find out if they stand for the thing you want. And but yeah, I get what you mean about how things can be that's odd. Oh. But I get what you mean about that. So anyway, let's see.
I just personally don't like telling people how to vote. If frequently clients will call me up and say, hey, got these local elections coming up, and who should I vote for? And I'll lay out who's running, and I'll tell them I'm voting for. But I hold jury service, jury trial, and voting, as sacred.
Mm-hmm.
So I just don't like telling people, you should vote for this person. I have
Right.
done that when I've been part of a couple of local judge campaigns, and of course, I'm advocating for them, and I'll tell them, yeah, you should vote for my guy, or gal, because I've backed lots of judges, and but telling somebody how to vote in a different state, but I can get you all the links, and I can get you all the information, and where you can make an educated decision. In Wisconsin, you can register up to the day of the election, but if you want to be registered and make sure you're all good to go, there's a cutoff about March 10th. You can register, you can print out an application online, but pretty much they make you go to your municipal clerk's office to register, but they've got an easy online way to check and whatnot. And I'll see if I can dig that up while you're looking through that.
Yeah. So Ripper makes an interesting suggestion. Not sure if we really want to be contacting the judges in this case, but
No, absolutely not. Be totally inappropriate.
Yeah.
And you could get a good one to recuse themselves. So no, you don't want to.
That's a fair point.
Judges.
That's a fair point. But what's up, Johnny? Good to see you, though. Let's see.
That's a good question. I'm glad they brought it up.
Well, he actually goes on to say, it'd be a perfect time to call the ones running, because they're running. So, I mean, that's a public thing if you're running for an office, right?
Right.
So, I think he was saying you could call them and get their opinion on the case. Be direct. And if they support and get elected, then just make sure you hold them accountable to what they said.
Right. Well, they won't comment on a pending case. That's the problem. But
Sure. Yeah.
And so I've framed this very, very carefully that, you don't necessarily want to have it be. It's why you don't see Zellner, but I could, I'm pretty confident who I know who she's hoping wins in this election. But you'll never see an attorney with a pending case before a court, be talking to those judges, even though they're candidates. It's just totally inappropriate. And it's just a fine line that, so let's say we were able to get out 25,000 votes for candidate X, okay? And that we're pro Avery, pro Dassey contingent. And that's who, or we raised $50,000. That, because the judicial elections are different than, governor and state senator and all of that. Like Harley Davidson, I'm sure all the time sends big checks to both candidates, and that buys you access. And everybody understands it buys you access. But when you contribute to a judge, it doesn't mean you're getting access. You're paying, what you're supporting is somebody who's going to be fair and open-minded versus closed-minded. And then who's open-minded and closed-minded varies based on your value, your issues, and what part of the, and I'm going to say it, political spectrum you're on. Who is open-minded or closed-minded. And so I think that's a great question, but it's just different. And that's why I'm like, if you know somebody in Wisconsin, encourage them to vote. If they need help sorting out, educating themselves on who's running for.
Okay, hold on. We got some questions coming in here. Okay, hold on. Will this step? Okay, Kim K asked, will this step be finished by the time of the election, or could a judge start it and then potentially not be able to finish? I don't know how it works. So Kim K. So the answer to that question is the judges that will be getting there will be 2 judges that potentially are going to be running for the Supreme Court, and those 2 judges are appeals judges. They're at the appeals court right now. This right now is being sent back. Yeah, this right now is being sent back to the circuit court, and Judge Sukowitz is not up for election to the Supreme Court. So Judge Sukowitz is not. She's the judge. So this is going to go to her. She's going to do what she's going to do, and then this is going to come back to the appeals court. And at that point, it could be after the 2nd. And one of those appeals judges could have made his way up to the Wisconsin Supreme Court at that point in time. So that's the answer to that question. Most likely, this stuff going back to the circuit court is going to be coming back to the appeals court after the 2nd. Most likely, that's my guess.
I agree. Yeah, absolutely.
And Jamie Hart says, so Travis, if you can't ask that type of question to a running judge, how in the world can you make an educated vote based on the fact that they won't state their views on cases? They will not. Let me answer that, please. He did not say they won't state their opinion on cases. He said that they will not state their opinion on a current case, a case that is currently being litigated. And the reason why that is well, precisely to avoid the exact type of thing that Ripper was suggesting to do. They don't want to do that with cases that are pending because then it hems them in, and they don't want to hem themselves in. So they will not comment on existing or current cases, but they will talk about past case law. I imagine if you ask them about past cases that are already resolved and done and over with, then they may offer you some thoughts there to let you know what kind of a judge they are, but just not with currently litigated cases.
Yeah, and there is a way to do that. You don't call them up at their judicial office. You call their campaign office, and you can say, what was your view of the way I want to know what Judge so-and-so's opinion of the decision in the Wierski case was.
Right.
But it's a judicial canon. It's like attorneys have rules of ethics, and judges also fall under a canon of ethics. And it's unethical and inappropriate for a judge to comment about a case that they may be presiding over. And both of the candidates are on Stephen's panel, and it could come back before them. And so it would be, and why there's a rule preventing it is you don't want cases turning political, even though they sometimes do, frequently do. That, you had one judge, hey, if I'm elected, I'm going to vote against this guy. Or if I'm elected, I'm going to vote for this guy. Mm-hmm. That's not the way it should be for judges, and that's why there's a rule that precludes them from commenting on a case that might come before them. And it might come before them if they're on the Supreme Court as well. So it'd be inappropriate for them to comment about this case, but they can talk about legal issues, and whether it's, where are you at on Second Amendment? Where are you at on LGBT rights? Where are you on whatever's important to you? Where are you at on, reproductive rights? Where are you on, whatever it is? And they'll either answer you or they won't. But it's not hard between these two candidates, take about 5 minutes of, very, very simple searching to know where each of these candidates are on all of those issues. Where they're, no judge knows where they're at on the evidence preservation statute because there's no reported decision on it. It's going to be, Zellner's going to be trailblazing on that one way or the other.
Mm-hmm. Okay, there we go. Okay, thank you, Jerome. I wasn't aware you were able to do the videos that fast. I only just got the Wrecking Crew working on doing the English translations. So amazing work if you were able to translate a bunch of them already to French. So congratulations, awesome on that. Obviously, would love to be able to have my videos reach, as many people as possible. So having French subtitles is actually a big deal. If it's going to help you at all moving forward, Jerome, I've already started the ball rolling. There's a couple people in the Wrecking Crew that are working on making the English subtitles on the videos, proper. And so that it actually, matches the words that I'm saying. Sometimes their speech recognition software gets it wrong. So I've got a couple members of the Wrecking Crew starting to do that. If you want to be able to just go to the videos that they've fixed first and start translating those to French, if there's still more for you to do. I'm not sure where you're at just yet. I know you were asking me about this a week ago, I think. So yeah, awesome, great. I'm gonna be checking them out probably today or maybe this weekend, I'm not sure. But thank you for doing that. We're very appreciative over here, so thank you very much, Jerome. All right.
So will you be speaking French on these?
No, he's just subtitling them in French.
Wow. Have you ever been subtitled in a foreign language before?
No.
Bonsoir, mon ami.
Let's see. You really do a great job helping us understand. Oh, thank you, Kim. Judge Suck will also now have to listen to the Supreme Court ruling on the evidence when she hears this about the bones and take that into consideration, obviously, hopefully, and not suck. I've hammered Trump by Twitter daily. Let's see.
Well, everybody could send her a dozen roses, I guess.
Right, but no, folks. I'm going to be reposting my Judge Flowers video now just because Travis said that, because you guys will do it. Don't do it. Don't listen to him. Do not listen to Travis.
That's disingenuosity. Peter was peaking right there. I was being cynical.
Yeah. Eric Jose, I watched the Darlute case, and it seems they did the same in that case with a couch as they did in the bones in this case. They gave the couch back to the family to get rid of it. Yeah, that may absolutely be. So how come Judge I Like Beer was able to, oh, that's okay. That's political. Interesting facts. Kratz and Schimmel play in the band together the last 20 years. Well, yeah, that's why I said I wonder if Mark Williams is taking Ken Kratz's spot in Alibi, because now Kratz is gone. Mark Williams is part of the team. So, anyways, but ask a judge how they feel about criminal justice reform. This is awesome. Let's see. It's cool. I actually wish I did. Feel sad for those living in Wisconsin. Don't feel so sad for the people living in Wisconsin, folks. I've been there. It's not such a bad place. It's got some problems, and hopefully its people are going to start getting that righted. But it's actually a pretty nice place, and the people are pretty cool. Jerome says bonsoir.
Bonsoir.
Bonsoir. Good night.
Au revoir.
Mon ami.
Mon ami. Au revoir, mon ami. I think that's awesome, Jerome, by the way, that you're...
I think Mark just got himself kicked from the band for playing the wrong song. That's brilliant, Allie. I love it. I love it.
Rhonda, if you just Google Wisconsin Supreme Court election 2019, it'll give you a bunch of links, and you can go from there to answer your question. That's what I did. I started with Ballotpedia, and it tells you who the candidates are, and the news and whatnot. But yeah, simple search, Wisconsin Supreme Court election 2019, and start with Ballotpedia. You got out of the band.
Go Mean Green just asked. Go Mean Green just said, "This is great. This is awesome." Go Mean Green just asked Jerome, "How do you translate disingenuosity and judge suck in French?"
Oh, that's classic, man.
I love it. Oh my God, that's hilarious. Oh my gosh.
Disingenuosity.
All right. Well, looks like we've gotten through the questions period. So I think we're getting ready to cut to Stacy here pretty soon. So if anybody has any final questions there you want to get in before we cut to Stacy, think of them now. Well, it seems everybody understands, and that's good. That means we do our job pretty well, buddy.
Yeah, so just be prepared. We're gonna... Today was a good day. What did you put now?
Go Mean Green said, "That's got to be a song, Stacy. Disingenuosity."
Yeah, just put it to the tune Velocity. That's awesome.
Oh my Lord. So let's see, what should we go with here today? Let's start out with 36 million.
How do you pay a debt when someone you owe 36 million? You don't.
You're welcome, Bella.
Be a gajillion.
You're all very welcome.
What you do, you charge the one you...
We're happy to make it more understandable for you so that you can understand the finer points. That's one of the reasons we're here. So happy you guys appreciate it.
Now first, you gotta have a body. I don't know how you get it, but I know that it's naughty. Find that car that body drove. Park the car in the yard, throw the body in the stove. Now this part, overemphasize I can't. You got to have a law enforcement that likes to plan.
Oh, I mean, not by a knee.
Talking about the bullets, a car and a key. How do you pay a bill for someone you owe 36 million? You don't. It might as well be a gajillion. Oh, this is what you do. You charge the one you owe with murder. The debt goes to.
Oh, thank you so much, Go Mean Green. Thank you. You're very kind.
Now you cook that body up. Oh, well done.
Thank you, Go Mean Green.
Pieces out for identification. Like the tibia, piece of 23. Oh, wait.
Some of you ain't following me.
But this brings me to
to be part of this scheme. You got to handle lab and forensics team.
Pick one out.
The dullest knife. Get a deviate the protocol this time in her life.
How do you pay a bill for someone you owe 36 million? You don't. It might as well be a cotillion. Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now I can't go into detail. It would take too long. This would end up being a 10-part, a docu-song. So I'll just give it to you. Oh, in poor form. Do all these things and you can toot your horn. You first have to get a kid to confess to the story you feed them. Block all the officers from following evidence where it leads them. Tell the media things that don't make sense. Don't worry, they don't ask questions, they just nod their heads. You gotta lock the
Like Newsweek.
from the scene. You got to beware now, dogs.
Oh, thank you so much, Julie.
Lose all the cameras, don't take a shot. Multi-label everything you got.
He's
You
not
gotta
36
keep
million.
all the evidence locked up safe. If anything gets broken, fix it with scotch tape. Then repeat. The bones were intertwined. The wires.
God, hey, Caden, there's rally in June 15th. June 15th, there'll be a lot of people there.
You don't. It might as well be a cotillion. Oh, this is what you do. You charge the one you owe with murder. The debt goes to. Now say you get away with all this stuff, but 10 years later you just don't have enough. Go write a book, try to cash in. Don't worry about the ethics.
There's none in Wisconsin.
Cause if there are, you would have been jailed and sued from all the domestic violence victims that you abuse. How do you pay your bill for someone you owe 36 million?
You don't. It might as well be a gajillion. Oh, thank you so much, Caden. Why is Bobby Dassey not in prison for his crime? Well, all right. Let's take a little break here before the last song to address that question for Caden. The only reason I can give you for that is that either there's not child pornography there, either he was just searching for it, which isn't a crime, or they did find something there that they could use against him, and they decided to get him to offer his false testimony in court instead of pursuing him on it. I am not saying that that is absolutely what happened. I'm just offering you two different possible explanations as to why that would be. So I hope that helps, but I don't know which one it is actually. So, all right. So back to Stacy. And I hope that answer helped, Caden.
Nancy Grace just posted Stephen Avery wins the appeal. Will there be a new trial?
Wisconsin can be so cold. The scales of justice can erode. If we accept lies big and bold, oh, we forget. We live on Avery Road. We live on Avery Road. Should be easy to see. This could be you, could be me. You shouldn't sit by idly, accepting everything that we are told. I live on Avery Road. I live on Avery Road. Avery Road.
Yeah, I did for a second. In fact, I need to clear something up here. I did get your super chat question, Caden. So that's the best I can answer your question. I don't know why the powers that be didn't do anything about it. There is some suggestion that there isn't actually child porn in there, that there was maybe just some searches for it. So these are all finer points that come into play. And like Ali was saying, I think she's right. It's up to the FBI to step in, you know, but was the FBI ever notified? I mean, these are all questions we can go round and round and round. But all I can say is I don't know, but these would be the relevant inquiries to make in regards to it. I wish I could give you a more helpful answer. I you know, but I do know that I've heard that it seems like it was just searches in terms of child porn, and right, Trav, and
That's
searches
correct,
are legal, right?
Well, searching in and of itself can be, but it depends. But the critical thing is so if you search right now on Google for child pornography or 10-year-old whatever, and you have certain blocks in on what photos will download, you cannot download them. And then if you can remove that, and presumably there may be stuff out there, but you hit the nail on the head. No one has seen, and I believe it's still under seal. We know what some of the searches were, but no one has ever seen what photos populated.
Mm-hmm.
And that, you know, depending on what populated, it is going to determine whether it's a crime or not.
Right.
Child pornography is both, a state, as far as I know, it's a crime in every state.
Right.
Possession of it, attempting to possess it, attempting to download it. And it's also a federal crime. But since 9/11, the priority of the FBI has been major drug stuff, which they've primarily passed off to the DEA, and anti-terrorism. So that it's got to be a major case for the FBI to get involved in it. But they will when it's a conspiracy that crosses over state lines and whatnot. But we just don't know. There's a lot of stuff we don't have. That's one issue. It's like, well, is that really the RAV4? All we have is, what Zellner's commented about it publicly is, yeah, that's the right RAV4, but there's still questions in people's minds that are interesting to look at, but our hands are tied because we only have part of the information. And so we know Zellner knows about it, but Did anybody ask her about that in the Q&A? Did Allie or Eric Jose, do you remember if
I don't recall.
Has anybody asked in a Q&A what, and there's another dynamic here. The Barb apparently is now cooperating to some extent with Zellner's crew. So,
Right.
It's not in Stephen's best interest for the FBI to go after Bobby Dassey, as hard as that may be to understand. But
yeah,
you want everybody, whether they're a potential third-party suspect or not, to be on friendly terms. And it's like she got Redaunt friendly with her, and look how much she was able to achieve with that. She got the bone. It's not on the Redaunt property. It's on the county property, the county that had a conflict, the county that had the most to gain by Stephen being arrested for a serious felony. So sometimes you gain a lot more momentum and a lot more traction, even if they're a potential third-party suspect. A Denny suspect is what they call it in Wisconsin. So no, you're not out there frequently to go out and trying to get people prosecuted and persecuted. I think it's one of those things that it's interesting to think about, and it certainly could be a motive to get Bobby to testify the way that he did. But I think what the most important issue about all of this is that it established time frames that clearly show that Bobby wasn't being fully forthcoming, let's say, about his time frame where he was that morning. And that's the important thing to take from it. But I think the short answer to your question, why isn't he being investigated? Why isn't he being arrested? Why isn't he being prosecuted? Is we don't know, because we don't know what he downloaded and we don't know what he saw. We just don't know. We have Kathleen Zellner's pleadings, and we have sealed exhibits, so we just don't know.
Right. Hey, JB, how you doing, buddy? It's always good to see you. Denise, good to see you. So I think that we've covered Caden's question now appropriately. I think we've gone through it. Are you satisfied with that? What we've kind of illustrated there, Caden? It's the best we could do. Unfortunately, I wish we could give you a better answer, but it's up to the powers that be to do something about it. So I'm going to inquire to the feds. Okay, I encourage you to do so. When you do, wear your Brendan Dassey control question t-shirt, just for giggles. Anyway, let's see later. Okay, statute of limitations. On anything in particular? A statute of limitations on the child pornography? What would be the statute of limitations on that?
Joe, no, I don't handle sex crimes or child pornography cases. Don't handle sexual assaults or.
So that's one that has to get looked up. You guys have to look up what the statute of limitations in Wisconsin would be on that, and federally. Honestly, you'd want to check federally too, because it's a federal crime. So, all right, folks. I hope you guys found it informative. We all got to talk a little bit about this development today. It's a pretty awesome development. It's a positive development for Stephen, which he doesn't get too often, so it's nice when it happens. So if you haven't already, please hit subscribe. We'll see you.